straight ahead on Law and Crime Daily.
And if somebody's outside of a vehicle and there's a bench warrant for a weapons violation, and if he tries to flee, you can use force to stop him, correct? Reasonable force.
Yes.
The prosecution and defense argue ex-cop Kim Potter's use of force. Was it justified? And
I blame Larry Nassar, and I also blame an entire system that enabled and perpetrated his abuse.
a settlement is reached, bringing some closure to survivors of Larry Nassar's abuse. Plus, will former White House Chief of Staff Mark Meadows face criminal contempt charges?
Do we have lords and nobles and friends of presidents who don't have to respond to congressional subpoenas or court subpoenas if they don't want to?
It is not up to individuals.
And later, did Derek Chauvin allude to a future change of plea?
There's going to be some other information in the future that would be of interest.
What we expect to see when the ex-officer appears in federal court. Law and Crime Daily, covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. Day 5 of Minnesota versus Kim Potter began with a win for the defense as Judge Regina Chu shot down 2 motions by the state, requesting the defense not be allowed to elicit expert testimony from law enforcement witnesses as the legality of Potter's conduct. This comes after startling testimony Officer Michael Johnson made on Friday.
And if he had taken off with you in that car halfway, what would have happened to you? What would you think would be the worst that would happen?
Probably dragged.
Dragged and what?
Injured.
Seriously injured, maybe even dead, right?
Yes.
And if that were the case, would an officer in your position with Officer Potter trying to stop him from resisting with you and resisting Lucky, would it be fair for that officer to use a firearm to stop him?
By state statute, yes.
Potter, an ex-Minnesota cop, faces manslaughter charges in the shooting death of Dante Wright, stemming from a traffic stop in April of this year. Officers say they pulled Wright over for unregistered tags. At the time, Wright called his mother and told her he was being pulled over for an air freshener hanging from his rearview mirror. Officers say they attempted to take Wright into custody after determining he had a warrant out for a gross misdemeanor weapons charge. Body camera footage caught the incident on video. It shows a struggle between Wright and the officers before Potter shot Wright in the chest as he got back into his car. Wright died as a result of his injuries. Potter says she accidentally grabbed her gun instead of her taser. On Tuesday, the prosecution called to the stand Commissioner Garrett Fleshland, who acted as Potter's supervisor at the time of the shooting. He told jurors about department policies and read excerpts from the department's handbook.
Why is it that this unnecessary force language or abuse is right in the Code of Ethics?
Force is significant if we use, and we don't want to use unnecessary force.
In the next line, it talks about the badge of my office as a symbol of public faith. How do you see that fitting in, that language, with your role as a police officer?
I think police officers have an incredibly important role in society. There's statutory requirements or statutory limitations, but I think there is a very special social contract that exists between police officers and the community. Police officers are an extremely forward-facing arm of the government, and it's a special role and relationship we have with society.
You're wearing your badge today, correct?
Yes.
What does it mean when you put that badge on in the morning to you?
It's a reminder that it was given to me by the public to go serve and protect.
This week, the jury also heard from expert Sam McGinnis, an agent from the Bureau of Criminal Apprehension. McGinnis told jurors the differences between a Glock pistol and a taser. While the prosecution made the weight difference between the weapons the center of the argument, the defense highlighted the similarities.
And when you weighed the firearm, what was included in that weight?
Ammunition.
17 rounds of live ammunition?
Correct.
And why did you weigh the firearm with ammo?
That would represent what was in the firearm the day of the incident.
And did you, you weighed both items, correct?
Correct.
Did you document the weights of those items?
Yes.
Okay, what were the results?
The firearm weighed approximately 2.11 pounds. The taser weighed approximately 0.94 pounds.
The Taser 7, or the tasers in general, have a handle that is similar to a gun, correct? There are differences, of course, but it's designed so you hold it in your hand, right?
Correct.
It's designed so that you pull a trigger like a gun, right?
They both have triggers, yes.
And it's designed so you aim at somebody, right?
Yes.
Joining us today is former federal prosecutor Gene Rossi and Terry Austin. Gene, testimony today focused on police policies. How are both sides using this to their advantage?
Absolutely, and I think the defense is doing a better job. The prosecutors having the officer or the commissioner testify about, flowery language that obviously everybody agrees with. But what the defense is doing very appropriately, if you're representing Ms. Potter, Officer Potter, is you're essentially saying she made a mistake pulling out the gun, not the taser. But given all of the circumstances that he had a standing arrest warrant, even if she intended to use the firearm, they're making an argument that she had a right to shoot him because he was trying to drive away and could have caused the harm or death of a fellow officer. It's actually the best argument they can possibly make. Whether a jury buys that is another matter.
Yeah, we'll wait and see. Terry, bifurcated or bifurcated, I guess, or unitary trial and Blakely issues were argued today. Can you break those down for us?
Okay, so under the Blakely case, a judge cannot enhance a sentence based on facts that aren't, tried by the jury or the defendant agrees. But the issue here is, can those be tried in a unified case, or can they be bifurcated and done separately if there's a conviction? The state said there was an agreement to do it together. The defense said, no way. The judge said, we're going to separate it. If there's a conviction, we'll do it after the trial. The one thing that the state got was Potter did on the record say she waived her right to a jury, but it's going to be done after the trial.
All right, so we'll see how that second part, if she's convicted, operates. It's similar to that of how Derek Chauvin had his trial for those aggravating factors that the prosecution put forward. Thank you both. We're also covering more news out of Minnesota as ex-officer and convicted killer Derek Chauvin is set to change his plea in federal court on Wednesday. Our legal experts will explain what that change could mean. That's just minutes ahead here on Law&Crime Daily. Still ahead on Law&Crime Daily, bombshell text messages released amidst the January 6th investigation. What messages Donald Trump Jr. sent Mark Meadows the day of the attack? But first, a massive settlement reached for more than 500 Larry Nassar survivors. All that and more still ahead. Welcome back to Law&Crime Daily. A monumental settlement is reached for the survivors of Larry Nassar's sexual abuse. The amount, $380 million. More than 500 girls and women were abused by Nassar, the former U.S. national gymnastics team doctor. Among the victims, Olympic gold medalist Simone Biles, Michaela Moroney, and Aly Raisman. The survivors come to an agreement with the USA Gymnastics and the United States Olympic and Paralympic Committee. This settlement comes as USA Gymnastics plans to exit bankruptcy following years of fallout from the Nassar scandal. And it's separate from the $500 million settlement with the Michigan State University. Nassar is serving a 60-year federal prison sentence on child pornography charges. He was also sentenced in a state case from 40 to 175 years. In September, Biles addressed the abuse to the U.S. Senate, saying Nassar and the organizations involved should be held accountable.
I sit before you today to raise my voice so that no little girl must endure what I, the athletes at this table, and the countless others who needlessly suffered under Nassar's guise of medical treatment, which we continue to endure today. We suffered and continue to suffer because no one at FBI, USAG, or the USOPC did what was necessary to protect us. We have been failed, and we deserve answers. Nassar is where he belongs, but those who enabled him deserve to be held accountable.
Back to discuss this major settlement is former federal prosecutor Gene Rossi and Terry Austin. Terry, the settlement doesn't stop at just $380 million. The Olympic committees also have to make safeguards so that this doesn't happen again. What could those be?
You know, I'll tell you, the money is important, but not nearly as important as these safeguards. The judge agreed to the settlement partially because of these safeguards. They made sure that the athletes will be safe and that they will be well and that everyone involved is accountable. One of the things they did was dedicate seats on the board and also in the committees to the survivors. So that is so they'll have some say in the decisions going forward. The other thing they did, Brian, is they made sure that the training is better and that there won't happen again in this way. And finally, the other thing they did is they made sure that reporting this type of misconduct can't stop with one person. There are different levels, and you are now required to report what goes on and to take it up to the next level. So these are changes that will help the girls in the future.
Now, Gene, the Olympic Committee is being penalized and forced to reform. But to Ms. Biles' point, what's going to happen to those who turned a blind eye, like the FBI?
Well, they have egg on their face. I don't know if there are any criminal charges. There may be civil charges. But it goes to what Terry just said about reporting. I cannot imagine that there were not multitude, hundreds of red flags and loud gongs for those 100 to 200 young girls that were assaulted. I can't believe that there wasn't some signal that this guy was up to no good and he was violating a sacred trust with his patients.
Yeah. Well, we'll continue to follow the story. Hopefully we'll get more good news in terms of reform and settlement so that this is not something that the United States Gymnastics or any gymnastics committee ever has to hear about again. Thank you both. Switching now to Wisconsin, where a 23-year-old accused of kidnapping and killing his parents faces a judge. Chandler Halderson appeared in Dane County Court on Monday, just weeks before the start of his trial. Prosecutors say Halderson reported his parents missing on July 7th after they didn't return home from their 4th of July weekend trip. Halderson was arrested a day later when investigators found his father's torso in a rural part of the county. Days later, his mother's remains were found in a different county. Investigators say Halderson used his Google account to search terms like body found Wisconsin and Wisconsin dismembered body found before he reported his parents missing. Halderson is charged with multiple counts, including first-degree intentional homicide, mutilating a corpse, and hiding a corpse. On Monday, a judge ruled both sides must present information about prospective jurors at the end of the month. Jury selection is expected to begin January 3rd. Coming up on Law and Crime Daily, Derek Chauvin is set to change his plea to guilty as the ex-police officer and convicted killer faces federal charges. Plus, former Trump Chief of Staff Mark Meadows takes center stage in the January 6th investigation. All that and more after the break. Welcome back. The so-called January 6th committee votes to recommend criminal contempt charges against former Trump White House Chief of Staff Mark Meadows. On Monday, the committee revealed January 6 text messages sent to Meadows from Donald Trump Jr. and prominent Fox News hosts, urging staffers to get President Trump to condemn the attack. This as a group stormed the Capitol following the 2020 election. The House Select Committee formed to investigate the riots voted on Monday to recommend Meadows be prosecuted for criminal contempt of Congress after refusing to testify before the panel. Meadows claims he doesn't have to testify because of executive privilege. All this comes as the D.C. Attorney General filed a lawsuit against dozens of members of the Proud Boys and Oath Keepers, extremist groups, calling their actions on January 6, quote, a coordinated act of domestic terrorism.
The executive privilege belongs to the President of the United States. Has President Biden come in to invoke executive privilege to stop Mark Meadows from testifying about what took place on January 6th?
No.
He is not, right? And has former President Trump, Mr. Chairman, although he has no say in the matter, but has he even tried to come into the committee to block the committee from taking Meadows' testimony? No.
Tuesday, the House took the next step in the process with a vote in the Rules Committee. That measure passed 8-4. It now moves to the full House for a vote. Let's bring back former federal prosecutor Gene Rossi and co-host Terry Austin to discuss the latest from the January 6th committee. Terry, the committee is still collecting facts, but so far, do you see any smoking guns?
Well, Brian, as you mentioned, it still has to go to the full House before it even reaches the DOJ. I do think there are some smoking guns. Listen, there are thousands and thousands of documents. Apparently, there are 1,000 texts just involving Mark Meadows. And I think it all depends on what did he know and when did he know it. And basically, you know, he's being urged, or he was at the time, to say something to Donald Trump. And the question is, did he say something or did he just ignore it? So we'll have to wait and see what happens. And basically, we really need his testimony, but we aren't going to get it.
Yeah. Gene, let's look even further ahead. As Terry told us, it's going to go to the full House for a vote, and then it goes to the DOJ. If and when it gets to the DOJ, what's that going to look like with these charges?
Oh, he'll be charged with criminal contempt. This is a slam dunk. There is absolutely no defense that Mark Meadows has. You cannot just ignore the subpoena. You have to show up. He didn't even show up. That per se is contempt. And if everybody did what Mark Meadows did, we'd never have congressional oversight.
It's going to be interesting to see how this plays out. They're, of course, going to try to enforce this, as you were saying, Gene, so that others don't just skip out when Congress asks him to come and testify. When we come back, Derek Chauvin set to appear in federal court with a change of plea. What a guilty plea could mean for the ex-police officer and why he likely made the change. Welcome back to Law and Crime Daily. Court dates are pushed back for the accused Michigan high school shooter and his parents as prosecutors sift through a mountain of evidence. On Monday, a judge pushed back Ethan Crumbley's probable cause hearing to January 7th after prosecutors requested more time to examine hundreds of pages of evidence. Crumbley faces several charges in connection to the November school shooting in Oxford, Michigan. 4 people were killed and 7 others injured. At the hearing, Crumbley's attorneys asked that he be transferred to the Children's Village that houses juveniles. The judge denied the request, ruling Crumbley will continue to be held at the Oakland County Jail. On Tuesday, Oakland County Prosecutor Karen McDonald requested more discovery time in the case of James and Jennifer Crumbley, the parents of the alleged gunman. Prosecutors say their case has so much evidence that there has not been enough time to work through all of it. Their hearing has also been rescheduled to next year. The couple is charged with involuntary manslaughter, for which they each face up to 60 years behind bars. Former Minneapolis police officer Derek Chauvin is expected to plead guilty in federal court on Wednesday morning in connection to the death of George Floyd. Chauvin is serving 22.5-year sentence after being convicted earlier this year of second and third degree murder and second-degree manslaughter in Floyd's death. A federal grand jury indicted Chauvin and 3 other officers a short time later, accusing them of violating Floyd's civil rights. Chauvin said at his sentencing in June that he couldn't make a statement because of other legal matters, but alluded to a possible plea deal.
I do want to give my condolences to the Floyd family. There's going to be some other information in the future that would be of interest, and I hope things will give you some peace of mind.
Chauvin is also accused of violating the civil rights of a 14-year-old boy during an arrest in 2017. It does not appear that he is changing his plea in that case. Gene, experts have suggested that Chauvin is looking to plead guilty to the federal charges, asked that that time run concurrent to the state time, and then serve his time in federal prison. Is that possible, and how?
It's possible. You got to put a rope through a needle because you have to have the agreement of all the prosecutors, state and federal, have to have an agreement of the state judge that once he's sentenced, he goes to federal prison, because it is a huge benefit. Federal prisons are much better than state prisons. I don't care where you are. The other thing I'm interested in is he gonna cooperate and provide inculpatory evidence against his 3 co-defendants as a result of this plea? That's something I want to see either in the plea documents or if it's an oral agreement.
Yeah.
We have to wait and see.
Yeah, and of course the difference, especially with federal and state charges in Minnesota, in federal charges you do 85% of the sentence. So if you're charged with 10 years. It's 8.5 years. But Chauvin's only going to do 2/3 of that 22.5. So they're going to have to do a little bit of math there, much better than the math that I could probably do. But Tara, let's move away from the math and let's talk about something else. At the sentencing of the state case, as we saw, Chauvin said that we would hear something more later. What do you think he'll say?
I do think he's going to express some remorse. I think he's going to also try to explain his actions. Remember, the federal court case has 2 federal charges against him. They're saying that he violated the constitutional right of Mr. Floyd by using 1, unreasonable force, and that he acted with deliberate indifference. And I do think, even though the case is very strong against Chauvin, I do think he is going to try, if he pleads guilty, to explain he wasn't using unreasonable force, at least briefly. And I think he's going to try to explain to the family and to the whole world that he does not have indifference. He did not, express indifference. He just thought that that was the thing to do at that time. So we'll see what happens.
All right, a lot of potential out there for what he could be saying on Wednesday, and of course we'll bring it to you when we get it. Thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.